So, about my subject, before stressing what I think are the main points on our regulatory framework, um, I would like to start with a brief context. So, the questions for me that are the initial ones to be made are: what is money laundering? So we all know how we can prevent it. What is the prevention of money laundering, so that we know exactly how to act? And where can we find the definitions, the support, the help for all of these? And where did all of this started, and where are we at the moment? It sounds pretty simple, which, as usual in law, I would say it's not. But I will try to cover these aspects, and maybe not so much by giving answers, but by posing questions, and obviously counting on you for a comprehensive reflection on this. So, to start with the legal framework, I've pinpointed two international instruments: the Vienna Convention, which was adopted in 1988. It's the United Nations Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances. And this is the first international instrument where we can find the definition of money laundering by the three stages. I think we all know those: placement stage, layering stage, integration stage. And the recommendations that I've pinpointed as well, which are the recommendations of the Financial Action Task Force. This was an intergovernmental body. It was established in 1989 at the G7 summit in Paris, and basically is a result of a growing concern about money laundering. And I was saying, this definition on the three layers definition of money laundering was also adopted on these recommendations. This financial task force was issued initial 40 recommendations. They were basically aimed at financial institutions, and they were revised in 96, 2001, 2003, 2012, and then later on there were other recommendations that were issued. But the main ones that are relevant for lawyers are the ones that I left written there, which is 22D and 23A, where they say that basically the recommendations regarding client due diligence and record keeping were also applied to lawyers in general terms. There are other international instruments that may be relevant in this context. For instance, the Strasbourg Convention of 1990, which was the Convention on Laundering, Search, Seizure, and Confiscation of the Proceeds from Crime. It was then substituted in 2005 by the Warsaw Convention. Then there's the United Nations Convention Against Transnational Organized Crime. It was adopted in Palermo, so it's known as the Palermo Convention of 2000. The United Nations Convention Against Corruption of 2003. But I've selected these two because for me, this is the first moment where prevention of money laundering actually pops up in international context. Then we do have several directives, EU directives and regulations that that are relevant in this matter. I just pinpointed 6 of them. The first one was adopted in 1991. It was focused basically the entities that were the focus of this directive were banks, and so it was revised in 2001, right after the terrorist attacks of the 9/11. And basically the second directive addressed the gaps that needed to be covered in the first directive, and included stricter regulations for additional obliged entities, and lawyers in this directive are considered to be in the list of obliged identities. Then the third directive, which was took effect in 2005 following a recommendation revision of of the Financial Task of 2003. This directive was relevant because it incorporated several changes on the due diligence measures, the processes, and it was the first one to introduce penalties for breaches in anti-money laundering measures, which was definitely a mark. In Portugal, where I come from, it was highly debated at the time because there were authors that believed that EU should not be sanctioning these kind of offenses. It was debatable about the EU power of sanctioning these kind of offenses. We discussed at the time if the predicative offenses actually justify these, and so it was a hard debate. This is a mark. And then the fourth directive, which was approved in 2015, also aligned with the Financial Task Force recommendations of 2012. Again, it offered a more comprehensive instructions for adopting a risk-based approach in client due diligence. New sectors were included in the scope of the obligations for preventing money laundering. Occasional transactions exceeding 10,000 euros were now also subject to these regulations, and several changes that I will address later on were included, and namely in what is related with the definition of UBO, ultimate beneficial owner. And then the fifth directive introduced big changes. Several matters were covered anew or were amended by this directive, namely prepaid cards, crypto exchanges, high-value goods, again, ultimate beneficial owner. And for me, I think it's probably the most relevant one at the moment. And then it was all together with the fourth, and then the sixth amendment. I'm calling the sixth directive because it introduces amendments to the fourth directive that are relevant for the matters that I will cover now. And it was issued in October 2018, amended the original money laundering directive. It revisited several crucial matters, including analyzing what money laundering is and who is liable for the offenses. This directive, I think it's the main point, the focal point. It establishes or formalizes 22 predicted offenses as relevant for money laundering purposes and includes, for instance, cybercrime and environmental offenses. There's another directive. It was issued in 2019. I did not include it here, but I didn't want to not refer it to you. I didn't include it because it wasn't, the amendments that it introduced were not relevant for the scope of the intervention. And now, currently, what we have already heard about today, the new AML package that is expected to be formalized soon, including a regulation that establishes anti-money laundering authority central one, a new anti-money laundering regulation, a new anti-money laundering directive, and a recast of the 2015 regulation on transfer of funds. Other than this, we need to take into account specific laws, regulations, or other that are relevant in terms of national or local. For instance, in Portugal, the constitution is relevant. What the directive, obviously, the law that enacts the directives internally, which was highly debatable, and others. For instance, our bar has been extremely interventive over the years. issuing recommendations, some helps on interpretation or some provisions, and so this should be considered. Um, at the moment, EU rules are implemented by way of domestic legislation, so these are at the moment particularly relevant. Obviously, that lawyers need to understand the directives, need to understand international instruments, need to understand the specific country or local laws. But for me, I think we also have to take into account our ethical standards. We do understand, basically, we do understand what money laundering is, and we need to understand how we can be a player on the prevention of money laundering, or at least avoid that any kind of liability lies on us because we may be considered taking part or aiding or facilitating any sort of offense. With the new package, local laws will probably lose a little bit of this importance because we will have a regulation that is going to be directly applicable. It's yet to be seen how is that each country obviously is going to tackle these questions. How is it that the new directive is going to be implemented? How the regulation is going to deal with the already implemented and enforce local laws. And so I think this is probably going to be the first challenge that we are going to face, is dealing and make sure that we will have a comprehensive and sustainable system within all these instruments. So currently, this is the definition of money laundering offenses. It's Articles 3 and 4 of what I've called the sixth directive. And it refers to Article 2 of the same directive, which defines criminal activity. The sixth, just a brief note, the sixth directive also changed what was the relevance of aiding and abetting, and it even gave a specific article, which is Article 4, saying that member states shall take necessary measures to ensure that aiding, abetting, inciting, and attempting an offense is punishable as a criminal offense. So, about lawyers, I think that the first question that we need to answer is, are we or are we not covered, or are we not bounded by these obligations of prevention of money laundering? And Article 2 of the fourth directive, which was then amended by Article 1 of the fifth, basically said, they didn't speak specifically about lawyers, but they said other independent legal professionals, and then explain in what circumstances those independent legal professionals are under the obligations of money laundering. I would say that based on these, criminal lawyers are basically excluded from these obligations, at least in the majority of the situations. And there are other circumstances, even not in criminal lawyers, for instance, an in-house lawyer, that are also excluded from this definition, from this scope of application, because an in-house lawyer, obviously, it may be subject, if the entity is subject, but he's not himself or herself obliged directly from this wording of the directive, the fourth, amended by the fifth. On the new anti-money laundering package, things are I don't know if I should start by my conclusion. I think this is a, how do you say it, a defective profession, that I start with the conclusion and then I explain. But for me, the new package is not changing substantially the framework that we have so far. So they do mention lawyers specifically, at least the revised version of the regulation. I think the first proposal did not mention lawyers. The wording that was being suggested then was the same as the current directives, so the independent legal professionals. The revised version seems to mention specifically lawyers, but the conclusion is basically the same, and that's what I'm saying, because nothing changes. Lawyers are subject when they are specifically carrying out one of those activities, which hardly is one activity that is carried out by a criminal lawyer. Obviously, there can be exceptional situations, or a situation if the lawyer is paid in money, then obviously that specific circumstance can be caught on the spirit of the directive. But I would say that in general terms, criminal lawyers' activity is out of the scope of the directive, of the directives and of the regulation. So moving forward, I was asked to address these three subjects: customer due diligence, UBO, and obliged entities. Regarding due diligence, since the first directive, that all EU members were mandated to enact legislation that ensured that due diligence on customers was carried out on onboarding processes. It was also a requirement to maintain records for 5 years after the termination of the relationship. And then on the second directive, I told before, lawyers were included in the list of obliged entities. And the second directive also introduced changes to the due diligence measures, and this is very important, took a major turn when it introduced the concept of risk-based approach. So the idea is having some flexibility on applying customer due diligence processes, and the lawyers should assess the situation based on several factors, for instance, the client's risk profile, the industry, the service, eventually the country. But the idea is take a risk approach and then define what kind of measures do we need to implement, if some simplified one or enacted one in cases of we conclude the client has a high profile risk regarding money laundering. So the activities that are comprised in the concept of customer due diligence are there. I'm not going to repeat them. You can find them in Article 13 of the fourth directive. And I've also left some relevant articles on this subject for you to have a look. Basically, I would say that the main points on these is that although the directive do identifies what are the measures that should in principle be comprised on the customer due diligence, it's not made a specific difference between simplified due diligences process and enhanced due diligence processes. These are Articles 11 and 13, if I'm not mistaken. Exactly. Articles 11 establishes the custom due diligences measures, and then the situations when you apply. Then Article 13, what the measures shall comprise. It's known as the 3QY, know your customer, know your transaction, and know your process. And then you have on Annex 1, some examples that help you assess the risks based on that risk approach. And then on Article 15, you have the definition or the recognition of a simplified customer due diligence, but you don't know exactly what measures are within these due diligence simplified processes, although you can relate to Annex 2 in order to help you identify what are the lower risk situations. And then Article 18, you do have the enhanced customer due diligence. And in these situations, basically the article says exactly, it was also amended by the fifth, but the article says exactly what are the factors that you should be taken into account. And then, let me see if I have my notes. And then, exactly, I think that for the directives that are in force now, these are the relevant messages. And for the new package that is to come, the same thing, the same approach applies. The risk approach and the distinction between simplified and enhanced customer due diligence is still a distinction that is being assumed by the new regulation. And what the difference is, well, there's one difference that pops up, which is the occasional transactions threshold will be at least 10,000, whilst now is 15,000. And specific measures for crypto asset providers and providers of gambling services are being introduced in the new regulation. There is also specific provisions for high net worth individuals, and specific attention is given to the high risk third countries when they have shortcomings on their anti-money laundering regimes that make it possible for them to be a threat to the integrity of the EU's internal market. Regarding the measures, the same. Well, there are slight changes, but in general terms, it's the same measures of due diligence to be adopted or used. Article 18 now specifically states what are the elements that shall be gathered, except in cases of low risk, which is a section a little bit further, section 3, and without prejudice, obviously, of potential additional measures in case of high risk. And then on Article 20 of the regulation, it's also detailed, which is also something new when opposed to the current EU framework. Article 20 details the information to be gathered regarding the purpose and intended nature of the transaction, and Article 21 of the monitoring of the relation or the transaction. There is a super simplified process for cash payments. So when there is an occasional transaction in cash to a value of at least 3,000 euros, obliged entities should identify the client and verify the customer's identity. And then simplified processes are in Articles 20C, 27, sorry. The difference is that there's a more detail. It's the detail one, the measures that can be applied, and then the enhanced due diligence measures on Article 28. Criteria and measures are pretty much the same of the current directive, except what I've been pointed there for business relations with a high net worth individuals with a high net worth in excess of 50 million. Then you can find on this new regulation several specific provisions and on specific situations. You can also find provisions on exchange of information on between obliged entities. It's Article 38, although the duty, it's still, it doesn't, it's not, it can't be transmitted. It's still on the obliged entity. And then I think it was told already here this morning, AMLA is expected to develop draft regulatory technical standards, and it will help, namely in this situation. One of the things that I think AMLA regulations or recommendations will be helpful is to identify which criteria to use or to take into account for identify occasional transaction and business relationships. Also, linked transactions criteria. And I think these two are the main points where some doubts can still be can still arise. Sorry, totally forgot. No, I'm good. I thought I have missed one of the slides. So here, one of the slides. Here is the ultimate beneficial owner matter. It's the current provision of the fourth directive. The fourth directive was the one that introduced this requirement, and it stipulated that individuals owning 25% or more of a legal entity must be listed in national registries. The idea of this measure was to enhance transparency within corporate structures, reducing the potential for financial criminals, obviously, to conceal themselves. This directive also addressed political exposed persons, broadening the definition to include also foreign nationals and domestically affiliated individuals with political ties. And then with the fifth directive, UBO registers were made public, as well as national political exposed persons list. Member states were also pressed to strengthen their mechanisms for verifying UBOs to ensure the accuracy, the reliability of the information, and to promote collaboration and information sharing among authorities of the member states. The Articles 30, sorry, the Articles 30, I put a note there in the end of the slide, 30 and 31 of the directive deal with the beneficial ownership of various entities that may be clients of a law firm, on the basis that it's important that lawyers understand exactly who are the real people behind a particular transaction, whoever entity may present itself as a client. And under Article 30, member states are required to have registers to which lawyers, among others, will have access. Article 30, number 8, stresses the risk-based approach that the lawyer should rely on, that the lawyers should take, cannot rely exclusively on this information. Lawyers should be proactive in terms of finding information and cross reference the information gathered. And Article 31 deals with trusts and other types of similar legal arrangements that usually may address some different questions on identifying the ultimate beneficial owner. Then on the new regulation, it is clear that the threshold relevant is the 25%. It is clarified that this threshold works in multi-layered ownerships and control structures, and with legal entities that have a higher risk of money laundering. This threshold can be reduced by the member states to a minimum of 15%. This is supposed to be discussed with the Commission. There have been several amendments and clarifications on the definition of UBO. But the idea is obviously to try to give the detail on both ownership and control, because these are the two components that are relevant for identifying who who exactly is our client, as in who exactly is the ultimate beneficial owner. The regulation provides also clarifications on the methodology, to be applied in order to assess the beneficial owner in a multi-layered structure, and provides ad hoc requirements for the investment fund sectors, for for the fund sector, and specific nominee related disclosures. Oh, the new regulation, I didn't put it there, but the new regulation also introduces the idea of supervisory colleges for non-financial sector, for supervision of non-financial sector purposes. And the new authority will be the one responsible for drafting the regulatory technical standards, which will define the general conditions for their operation. At this point, I think that little information is still available. Then on the directive, I didn't put it there because it was something that is already on the current directive, but the directive mentions that the obliged entities can have access to the public register, and also addresses who holds a legitimate interest that can justify the access to that public register. Then on the point of obliged entities, there are changes, relevant changes, or on who are the entities that are now obliged by the anti-money laundering provisions. I've specified the three that are the most relevant, although there is flexibility on the member states to remove at least the professional football clubs from the list if they represent a low risk, is something that is also being addressed to on the regulation. And these rules will apply in principle on a longer transition period. I think it's 5 years instead of the standard 3. Then my second point, which was lawyer-client confidentiality. So the thing here basically is the directive on Articles 33, the current one on Articles 33 and 34, establishes reporting obligations. So, and I'm talking about lawyer-client confidentiality because this regimen kind of changes a little between countries, and sometimes even within the countries. Sometimes it's a legal privilege and sometimes it's a secrecy. And so I'm just putting it broader as lawyer-client confidentiality. But obviously the idea is how do we balance these two concepts, the reporting obligations on one side and the confidentiality on the other side. And basically, current directive establishes on these articles that a lawyer shall inform the National Financial Intelligence Unit when he knows, suspects, or has reasonable grounds to suspect that the funds which form part of the transaction are the proceeds of criminal activity or are related to money laundering or terrorism financing. There's a very specific and important provision, which is that member states may allow bars to take over this reporting duty. And this has actually happened in several member states, which means that lawyers would be then obliged to report not to the Financial Intelligence Unit, but to their professional bars. It's there's also the directive also includes an exemption for lawyers, but in very strictly limited circumstances, which is basically when they are asserting the legal position of their client or defending or representing the client in judicial proceedings, which was, again, if criminal lawyers were to be included, which I think they are not, at least in majority of the times, they would probably fall within these exceptions because because there's at least this reference to judicial proceedings. There's also a duty to abstention, which is basically the lawyer is not supposed to continue to act for the client after he makes a report, which you can see on Article 35 of the fourth directive. I've chosen three cases or three international references in this purpose regarding the balance between these concepts that I was mentioning. The first one, basically, the Commission decided that community law that derives not only the economic but also the legal interpenetration of the member states must take into account the principles and concepts common to the laws of those states concerning the observance of confidentiality, in particular as regards certain communications between lawyer and client. That confidentiality serves the requirements, the importance of which is recognized in all of the member states, that any person must be able, without constraint, to consult a lawyer whose profession entails the giving of independent legal advice to all those in need of it. This case was revisited by the court a few years later, but the essential principle was maintained, and the court also noted that this principle is closely linked to the concept of the lawyer's role as collaborating in the administration of justice by the courts. This is an international recognized principle, and at least in Portugal is something that it's usually given a lot of importance to. Then I've selected a principle 4 of International Bar Association, Principles on Conduct for the Legal Profession, which also states that a lawyer shall at all times maintain and be afforded protection of confidentiality regarding the affairs of present or former clients, unless otherwise allowed or required by law and or applicable rules of professional conduct. And then there was a relevant case, I think it was one of the first, of the European Court of Human Rights, which basically related with Article 8 of the European Convention on Human Rights, and the court concluded that yes, Article 8 protects the fundamental right to professional confidentiality, but the fact that lawyers may be required to report suspicions did not amount excessive interference with their right. And Human Court of Human Rights is also very sensible to the fact of the existence of the supervisory authority where the reports can be made, namely if it's a professional bar. So to conclude all these ideas, obviously that if the lawyer does not report when he is required to report, he's open to criminal liability or disciplinary liability, obviously. But the requirements of the directly only operate within specific situations or a conjugation of situations. The first, the fact that lawyers and transactions are actually covered by the scope of application set in Article 2. Even if the lawyer is included in that definition, there are exemptions of reporting, which I've addressed. And then you should also take into account other relevant definitions. For instance, criminal activity, which is defined in Directive 6, in order to know if that is something that is relevant for falling within the scope of the directive. I don't know, where am I in terms of timing? Sorry. Off? Okay, I'll try to summarize my next points. So, The new regulation sets a new provision of reporting of discrepancies. So when the lawyer, when the obliged entity finds discrepancies, they should report those ones. They should ask the client to make the correct report, and if the client doesn't, then the obliged entity should do that. This article does not apply to lawyers if this information is obtained in the course of asserting the legal position of their client, or when defending or representing that client in a judicial proceeding, including advice on how to avoid or how to deal with that file. It is irrelevant if the information is received or obtained before, during, or after the judicial proceedings. Article 17 also covers the abstention duty that I've mentioned, but also says that it doesn't apply to lawyers in the same situation as I was mentioning before. And then the reporting obligations are detailed in Article 50 of the regulation. There are deadlines, I think it was mentioned this morning, 5 working days, 24 hours in urgent cases. And then 51 also Article 51 also allows that this reporting is made to a regulatory body. Then, my last point, sorry, whistleblowing, internal investigation, and sanctions complying. I'm going to be very brief. Basically, currently, the directive, Article 58 and 59, says that at least breaches that are serious, repeated, and systematic, or a combination of these, shall be sanctioned. Then it sets a series of administrative sanctions that can be applied in Article 59, and the factors that should be taken into account in order to set these sanctions on Article 60. And then Article 61 contains provisions in order to protect whistleblowers. The new regulation, it's not as much the regulation that is relevant, it's the directive, which basically says, one, in Article 28, the confidentiality of reporting, and the regulation sets that on Article 11A that the directive on protection of whistleblowers shall be applied on these circumstances. My last point is that the new package, AML package, now makes specific references and distinctions between pecuniary and administrative measures as sanctions that can be applied. A final note that this package is supposed or expected to be adopted within the end of the month. But obviously, it's not going to be implemented immediately. It has at 3 years. The directive is going to be should be entered into force within 3 years, and the regulation also 3 years after it is approved. So we would say that at least mid-2027, we will still be dealing with this currently framework of the 4th, 5th, and what I call 6th directive, unless any specific country anticipates and decides to regulate on the directive, which I think, taking into account all the questions that need to be tackled, that it's not the most probable scenario. Thank you so much for your attention. I'm so sorry for the time. And obviously, if we have the time, it doesn't need to be now. I will be around. So if you want to share any experience or have any questions, just let me know. Thank you.